Go ahead.
Namaste and greetings. I, Ritika Pandey, researcher at IMPRI, Impact and Policy Research Institute, Prabhav एवं नीति अनुसंधान संस्था, Nai Delhi, extend my warmest welcome to all to IMPRI Web Policy Learning. Today, we are gathered here for the inaugural day of the LPPYF Law and Public Policy Youth Fellowship Cohort 3.0. The theme for this cohort is Advancing Justice, Bridging Gaps in Public Policy Enforcement. We welcome you to join us for an immersive journey into impactful policy and action. The chair for the program is Professor Vibhuti Patel ji, Visiting Distinguished Professor, IMPRI. The lead advisor and legal hands on sessions will be dealt by Advocate Dr. Shalu Nigam ji, Visiting Senior Fellow, IMPRI, Advocate, Author, and Researcher, Gender and Human Rights. Our expert panel for the program includes Professor Abdul Hafiz Gandhi ji, National Spokesperson, Samajwadi Party. The conveners for this course are Dr. Ajay Gudarvarthi ji, Advocate Selin Thomas ji, Dr. Simi Mehta ji, and Dr. Arjun Kumar ji. Proceeding further, we welcome everyone to this transformative journey and appreciate your dedication in investing your time, energy, and commitment to gaining a profound understanding of the crucial role and intricate details of policy and action. We have also shared course outline and reading resources in your email for your kind perusal. Before we start today's session, I would like to state the housekeeping announcements. Please join the meeting on time. There will be question and answer session after each presentation. Share your questions on the question and answer box. The questions must not be posted as an anonymous attendee. Ensure that your questions are precise. Refrain from making general comments in the question to save time. To begin today's session, I would like to invite our chair, Professor Vibhuti Patel ji, Visiting Distinguished Professor, IMPRI, to give her opening remarks. We welcome you, ma'am, and over to you.
Thank you, Ritika Pandey ji, for introducing the course. And I welcome Dr. Shalu Nigam and Dr. Professor Abdul Hafiz Gandhi for today's session. A brief recap of what transpired in the previous days. Day one, in the with the inaugural address, Mr. Shailesh Gandhi ji, he focused on was a very wonderful data-driven and detailed conversation on a time-bound justice. And he came with a very important data sets and also showed that according to Niti Aayog policy paper, it will take 324 years to clear backlog of the cases in India. And he also declared that we don't have a justice system. What we have is an injustice system. And what he also provided an equation that delayed justice is equal to injustice. And he said that at the current speed, even by 20, we will land up with the 10 crore cases. And that is why it is very important that we galvanize the forces and we make the system accountable by creating pressure from the bottom-up pressure, and by mobilization, we can make the system work. After that, Sri Sandeep Chachra's lucid lecture, it began with the perspective on social justice, which is an approach of thinking of an egalitarian society, and how well-being and opportunities can be distributed equally. He talked about the idea of Dr. Ambedkar, his vision of egalitarian world, and he said that how his organization, Action Aid India, they came up with the people's agenda through participatory processes, and they visited 300 districts, 51,000 meetings they organized, and they had an interaction with 18.5 lakh people over last 8 months, in which they made cross-section of the toiling poor, basically Dalit, bonded labor, sugarcane workers, salt pan workers, denotified tribes, nomadic tribes, criminalized tribes, informal sector workers, craft persons, construction workers, scheme workers, waste cleaners, and night soil cleaners, and came up with a agenda of action. So I think that was a very important process, and how to ensure, expand the scope of social security, social justice. And they said that when we talk about, and then we also had a very interesting discussion that what do we mean by social justice? It is just a quota or a percentage or some relief measures, or it has to go beyond that and talk about the human dignity, respect, the way Periyarji and Ambedkarji talked about. Day two, we began with Dr. Shalu Nigam's introduction of the topic on human rights discourses. She touched upon global hunger index, income inequality, plight of millions of crores of gig workers, colonization of entire market by big corporate houses. She also mentioned the recent struggle by Amazon workers who are working in the midst of heat wave. And she also touched upon the issue of homelessness of millions of people. She quoted Oxfam report, Survival of the Richest 2023. And again, she brought in the same issue of how the legal system, the judicial activism, or the organizations such as People's Union for Civil Liberty, their petition on right to life. And she also quoted Professor Upendra Bakshi, where he talked about all these bottom-up initiatives as a constitutional politics. And she also asked a pertinent question that how to make state accountable, and are state agencies standing with the people or they are against the people? I think this is a very, and where are we? Are we taking sides or we are just neutral observer? After that, Dr. Vaida Nayanar's talk began with an optimistic note on a largest event of the democracy. We had just got the result on 4th of June of the 18th Lok Sabha election. She profiled a spectrum of democracy in terms of involvement of people, greater degree of participation of people, formal, and she also differentiated between the formal democracy and substantive democracy. She talked about models of democracy such as pluralistic democracy, representation of diverse interest groups, the way you have democratic procedures in USA, or the referendum-based democracy in Switzerland, or deliberations as an essential part of legitimacy of the governance in Canada, or beyond the procedural aspect of democracy and institutionalization of inclusive form of democracy in the Scandinavian countries such as Norway, Sweden, Denmark, and the election systems of the decentralized governance, say from the village level, where the decision-making should not be only reduced to voting, but it should people should have an actual say, decision-making power. She spoke about the holistic democracy, which is a continuous process, and raised serious concerns about undermining of democracy, pluralism, tolerance, and vibrant civil society and effective governance in the recent times, not only in India, but in several parts of the world because of the massive global right-wing, conservative and sectarian wave in the politics and governance that we have experienced in the 21st century. She emphasized that for the meaningful democratic outcome, we must have participation of wide range of stakeholders in the decision making. And she also gave examples of how majoritarianism curbs minority rights, women's rights, and she gave ample examples from Algerian Revolution, the recent curtailment of abortion rights in USA or in UK after Brexit, or the recent developments in Germany and European Union election, where so many gains which were made in the past have been reversed. After that, the last presentation we had was by Professor Sina Paul, who talked about the whole grammar of research paper writing, which were covered in 10 steps, namely preparation of abstract and introduction, review of literature, research gap in subject area of inquiry, research methods, findings and analysis, discussion, limitations of your research, and future scope, and how to do the referencing. And to discuss each step, Dr. Professor Sina Paul also gave several examples for her last full of research studies she has conducted over last 3 decades. Today, we shall understand how the grassroots politics determines public policy enforcement and democracy as a political regime and a political system in which people are recognized as source of power and are facing newer challenges, and we will get it from the practitioner who is active in a political party and who is a very articulate and who is also makes a very rigorous analysis on the democratic governance. Over to IMPRI. Thank you.
Thank you, ma'am, for walking us through the introduction of this program. Now, I'm delighted to invite Advocate Dr. Shalu Nigamji for a legal hands-on session. The floor is all yours, ma'am.
Thank you so much. So I'll just begin with sharing my screen, and today we will talk about access to justice and how it can be it can empower poor and marginalized. Because we are talking about justice, we see in first session that how justice is being delayed and denied, but then the justice should also be able to reach to people, and for this we will
You can make it full screen, madam.
yes, ma'am.
Fine.
Yeah, so the discourse on the law and legal system, it's basically, being centered around collegium system, because if you're reading newspaper, you're watching television, or you're generally talking about, you see that a lot of discussion is being held on, how the judges are being appointed, what is the pendency of litigation, the number of judges, the number of courts, that we have, less and less number of judges and more and more number of cases. So this discussion is going on. But when we talk about the law and the legal system, now the system is being created for the common citizens to address their grievance, and basically the state and the police machinery, it's all about maintaining rule of law. So when we talk about resolving the grievances of the citizens, so what we have to also focus on the kind of problems the litigants face in accessing to justice, in terms of infrastructure of the court, in terms of how the court is, how far it is from, if a person is living in a village, can that person access to the high court or the session court, district court. So all these problems are there, and plus there is a language of the law which is very technical kind of language. So what has been done to really simplify this language, to demystify the law? And what about the cost of litigation? Because many of the times litigants don't file cases, or they don't approach to the justice system because the cost is very high. So international provisions relating to access to justice. Now there is a UN principle and guidelines on access to legal aid. This is in 2013. And it says that legal aid should be recognized as an essential, important element of fair, human, and efficient system based on rule of law. And that includes right to fair trial. So similarly, if you talk about sustainable development goal, that is goal number 16, which is about peace, justice, and institutions. It is committed to build effective, accountable, and inclusive institutions, and all by year 2030. So this is an important book which is being written by a person in USA. That person has pioneered the legal aid movement. And what this person is saying is that without equal access to the law, the system not only robs the poor of their only protection, but it also plays in the hands of the oppressors the most powerful and ruthless weapon ever invented. And what we are seeing right now is that sometimes the law is being weaponized by the rich and the powerful, and sometimes by the state too, where the poor are being denied justice. But we have Article 39A of the Indian Constitution, it talks about equal justice and free legal aid. It says that the state shall secure the operation of the legal system that promote justice on the basis of equal opportunity, and the state should provide free legal aid, and there should be suitable laws and schemes which should be put in place. And this Article 39A, this was inserted in the Constitution by 42nd Amendment in 1976. Now, according to this provision of the Constitution, legal aid is seen as a vital function of the welfare state, and it is seen as essential in providing access to justice by ensuring equality before law, by having a right to advocate, and by a right to fair trial. So in India, we have the range of systems. For instance, we have pro bono lawyers. Now, pro bono lawyers are again different from traditional lawyers because sometimes they provide free legal aid. Then we have NGOs, we have system of paralegals, we have state-funded legal aid centers, and there are those which are supported by law schools and universities. So the right to citizen, that is important in terms of having access to legal process, and it should be available without any discrimination. And mostly, more important is that it should be made available to the weaker section of society who do not have means and resources to really reach to the courts or to the police or all kind of mechanism we have. And we also need to have to give special attention to women, children, elderly people, and people with disabilities. So the provision, the aim is that to ensure justice to all, and the cost of proceeding could be a major barrier, so that should be removed. So the need was felt, in 1976 because now. We have to realize the legal aid, that goal for everyone, and everyone should be able to afford justice and should be provided equal opportunity to get the legal aid. So that's why we have this provision. So if you see that even in 1956, there was a report of the Law Commission on Legal Aid, and which says that there is a need for legal aid to provide it to the poor and marginalized sections, because they couldn't, access justice. So if even their Supreme Court cases, time and again, which have highlighted, the need for the free legal aid. So in 1973, we have this Hussain Ara Khatun versus State of Bihar. It's a landmark judgment in which the right to free legal aid is being held as an integral part of the right to life, that is Article 21 of the Constitution. And this judgment says that there's a need for legal aid, which should be provided to all persons. Now, in this case, there were some prisoners who were languishing in jails as under trial for so many years because they couldn't afford a lawyer. So that's why, one of the advocate, Mrs. Kapila Hingurani, she filed a public interest litigation, and then on that petition, the Supreme Court gave this judgment, and it says that the under trials should be released immediately, and nobody should be held just because they couldn't afford a lawyer. So similarly, in a number of other cases, the court has said that you have to reduce pre-trial kind of, under trials couldn't be kept inside the jail without any trial, and there can't be number of wrongful convictions, because these cases re-victimize the victims. There are cases of custodial violence, there are cases of custodial deaths. So in all those cases, because the legal aid couldn't be provided, the persons cannot go out of the jail, and they have been some people have been forced to die in the jail. So these kind of the judgments are coming out from the courts. So based on these kind of recommendations, a Legal Service Authority Act 1987 was enacted by the Parliament. Sorry. So the word this word service is being used because it indicates that it is not a voluntary help. but it is the obligation of the state to provide legal aid service to the poor. So the income limit, which is determined for the Supreme Court, is rupees 5 lakhs of annual income. If your income is less than that, you can approach to the court for this Supreme Court Legal Service Committee and ask for the legal help. In Tamil Nadu, this income limit is 3 lakhs. In different high courts, there are different limits, so you can check with your state. So the Supreme Court had said that that a poor person should be provided legal aid, and sometimes the court appoint amicus curiae. Amicus curiae is a kind of a lawyer who help the litigants. If the person can't understand the technicalities of the law, lawyer will be appointed, and they can help the petitioner, the person to understand the law. A person can also argue his or her own case as petitioner in person if you go to the High Court or to the Supreme Court. So under this National Legal Service Authority Act, we have different kind of authorities which are being formulated at different levels. So we have at national level, we have at state level, districts level. In Supreme Court, we have Supreme Court Legal Service Committee. In every high court, you have a legal service committee, and even at taluk level, there are legal service committees. So the act mandates that that every state government should establish a kind of authority at at every level, and these authorities should provide free legal aid to the weaker sections of the society. So basically, what they do is they provide legal advice. They hold legal literacy programs. They conduct lok adalats. They conduct mediation and conciliation. They help the victim in obtaining compensation in case wherever is applicable, and they provide legal aid. So who can apply for the legal aid? A person, and how can apply? So we have talked about who can, if your income is less than a given limit, and how you can do that. You can approach to the concerned authority. You have to fill an application form, and where you have to say that what is your income, and you can seek legal aid. So you can also apply online, and there are legal service schemes for for different categories. Like for differently abled children, the scheme came in 2021, and there are whole lot of schemes which came which are applicable to senior citizens, to the victims of acid attack, to the victims of trafficking and commercial sexual exploitation, to the workers in the unorganized sectors, for mentally ill people. And there you can go to the website and you can check the schemes, and accordingly one can apply. What are lok adalats? Now, lok adalats are the kind of substitute of dispute redressal mechanisms. The legal service authority, they conduct lok adalats time to time, and where both the parties, if they agree, they can come together and they can compromise the case. So what is the composition of this lok adalat? It consists of a chairman, 2 members, and 1 social worker. The chairman could be a retired judicial officer, and there are 2 members who should be lawyers. And it can give a final award in terms of the applicability of the award is in terms of verdict of a civil court, and it is binding on the parties. So basically, the purpose is to provide amicable resolution in a very fast, in a very quick way. And the members, they assist the parties to reach to a cordial settlement. And again, there is no appeal to the against the verdict made by lok adalats. If the parties are not satisfied, they are free to initiate litigation. There is no fee the person has to give, so if you have already paid fees, that could be refunded. So why this lok adalats system is being initiated? Because of pendency of cases. So the makers of the scheme thought that if the parties agree, they can come together and they can settle the cases. because a lot of cases, pendency, we have already discussed that cases are pending for so many years. So it's a party-driven process. And as per the data provided by the National Legal Service Authority, more than 15 lakhs of cases have been compromised by the Lok Adalats. So out of the system which has crores of cases pending, this could be one of the speedier process to get the settlement. So basically, the law they apply is Code of Civil Procedure, Indian Evidence Act. So not the criminal case, but only the civil cases could be settled through Lok Adalats. So, but there are limitation in terms of, if the parties are at the unequal position, because if the parties are in unequal position, the compromise could not be made, and it could be, imposed by one party on the another party. So that is the problem where, the justice is undermined, because in majority of cases in India, litigants are pitted, because there could be a rich party, elite party, and there could be major the state institutions such as electricity boards or insurance companies or banks, and there could be another side, there could be one vulnerable person. So in that case, if you are compromising, then you have to really see that kind of power dynamics, what kind of power dynamics are playing. So in terms of legal aid, now legal aid is basically provided where 3 lawyers are being appointed by the Legal Service Authority. Now what has happened is that very few lawyers have been appointed as legal aid lawyers by the state. As of March 2022, India has only 50,000 plus free legal service providers, and in terms of per population ratio, if you see, that is very high. So there are just 5 legal aid lawyers per 1 lakh of population. And again, the state-wise distinction is there. So Maharashtra has highest number of legal aid lawyers, and Mizoram has the least. A study by the Orissa High Court in 2004, it says that the majority of funds which are being made available for the legal aid services, they are being utilized for administrative services rather than providing legal aid itself. In 2018, Commonwealth Human Rights Initiative, they conducted a study, and they say that legal aid, the money spent per capita expenditure is only 0.75 paisa, which is one of the lowest in the world. The Tata Trust India Justice Report 2019 and 2020, that report says that per capita legal aid spending is only rupees 1 rupees. Now, as per again the Indian Justice Report 2022, in terms of they analyze how much spending is being incurred on police, judiciary, prison, and legal aid. So in terms of police, the spending is only rupees 912 in 2017-18, and this increased to 1151 in 2020 and 21. So the budget, if you see, it's very less, and most of the budget is being spent on administration rather than actually providing services. So and many of the states, they have not utilized the funds which are being given to them by the center. So those are the problems which the entire legal system is facing in terms of spending per inmate in prison. Now, when you are in a prison, or the expenditure being incurred on a prisoner is in terms of food, clothing, medical needs, vocational training, education, and welfare activities. Now, whatever the budget being allocated, the state could not utilize those budgets. So if you see, only 31% of the budget is being utilized for 21-22, and nationally 16 states and union territories, they spend rupees 35,000 per inmate annually, which is less than rupees 100 per day. in terms of spending on police, the number of police stations and how much. So if you talk about one police station which is available for 78,000 people, which covers 187 square kilometers of area. So we have all over India 17,500 plus police stations. The National Police Commission of 1981, it recommends that the area which should be covered should be 150 square kilometer for a rural area. So our prisons are overcrowded. Our police stations are in such a situation. The model prison manual it says that there should be one doctor available for 300 prisoners, but we have very shortage of the doctors and medical staff. So the Supreme Court former judge, he says that legal aid to the poor does not mean poor legal aid. There has to be better standards and better quality and better level. So what could we do to improve the entire legal system? So we have to spend more in terms of infrastructure, in terms of police, prison, and judiciary. We should involve law schools in the justice delivery process, because in UK, a study revealed that a university-run legal aid clinic could handle an average of 104 cases per year. But in our country, we have to do such kind of studies, and how many universities are taking up this kind of projects that we have to see. So per capita spending of the budget and allocation for the National Legal Service Authority, that has to be increased. Now there are companies who are spending money as corporate social responsibility, so that fund could be diverted for legal aid and for providing better compensation to the panel lawyers. And in terms of infrastructure of not only the courts, but also of police station, and legal aid clinics, that has to be improved. So we need to have more trained lawyers and paralegals across the country, we have to improve the ideas, thinking about legal awareness, legal empowerment, capacity building, judicial advocacy, that we have spoken in last session also. But how the civil society has helped to demystify, this complicated law and the legal system. Now, civil society, that means a lot of NGOs, a lot of community-based organizations, non-profit groups, and the women's movement and human rights movement, and different kind of organizations. They are taking up a lot of the kind of legal aid. They are providing legal aid. They are providing. They are simplifying the laws. They're providing legal awareness. They're doing gender sensitization. So they're trying to change the environment and more in terms of dignity and rights of people. So this is just kind of vocabulary, new kind of vocabulary and grammar being introduced in law. For example, for single mothers and single women. Earlier, the law only has provision for widows, so they don't recognize single mothers or single women. So now the NGOs are using terms like ekal maa or ekal mahila. Disability. Earlier there was a lot of stigmatization associated with disability. So now the organizations which are working in this field, they are calling people as differently abled. Now the RTI was surely a new kind of law which has been introduced by the civil society groups, by NGOs. So they have given this new terms such as Suchna ka adhikar, hum janenge, hum jiyenge, hamara paisa, hamara hisab, right to food. As we discussed, that it came out of a huge campaign on right to food. So it talks about bhojan ka adhikar and right to life or jeene ka adhikar. Fraternity and peace. Now there are various Shanti or Bhaichara sammelans which are being held at various places after this hate speech and all kind of mob lynchings and other kind of incidents. So similarly, if you talk about rape, menstruation periods, sanitary pads. Now, before Nirbhaya protests, the rape, even if you go through the judgments, the way the victims were in their testimony, the way they were using the language, it's more about, Gandhi baat ki, Gandhi harkat ki. Now that vocabulary is also changing, with women's movement playing a strong role in changing this vocabulary. So different kinds of legal literacy campaigns which are being taken up by different groups. So a lot of posters and this kind of legal literacy material has been made, and they're talking about changing the laws, making new laws, and addressing issues such as corruption and all. And so I'll just end here with this quote by Justice P.N. Bhagwati, and he says that the quote, and I will add here the civil society, that means all of us, we have to innovate new methods and strategies to provide access to justice to large masses of people who are denied basic human rights, to whom freedom and liberty have no meaning. So with this, I'll just end my session here, and we can have question and answer session.
Thank you, ma'am. Now, we would like to invite Professor Vibhuti Patel ji for her remarks on the session. Patel. Over to you, ma'am.
Hello, Nigam, for taking us through this whole journey of legal aid initiatives. And I think it was also the pressure of the social movements of the late 70s, early 80s, and especially in the post-independence period, that we got so much of judicial activism, and also that 1987 Legal Aid Act we got. But I just wanted to know the relationship of the courts with the Lok Adalat and relationship of caste and community panchayat and Panchayati Raj institutions with Lok Adalat. So what is the locus standi of Lok Adalat vis-a-vis caste panchayat, community panchayat, Panchayati Raj institutions, and the court of law?
Yeah, that's very good.
Generally, a lot of confusion exists even among the civil society organizations.
Yeah, so the Lok Adalats are being constituted under this act, National Legal Service Authority Act. So the Lok Adalats now, again, it has a composition. It consists of a judge and the lawyers and other members. But if you talk about panchayats, the Khap panchayats, Jati panchayats, and that was a different system. That was a village level kind of system where the few leaders of the village come together, and they don't have any knowledge. They may not have any knowledge of law. But here we are talking about people who have legal background, who are the retired judges and the lawyers. So that is a major difference between these two kind of systems. So that is definitely the Khap Panchayat, Jati Panchayat, they are not legally recognized, but this is legally recognized. This has to go by the constitutional laws and whatever the laws which are applicable. Now, again, the Jati Panchayats and Khap Panchayats, they have their own local laws, local traditions, customs, or whatever. So that is very different from this kind of institutions. So this difference in terms of how they operate, the knowledge system, and the way. And again, the Lok Adalats, they only take up civil cases if both the parties agree. And if you talk about the village level system, the panchayats, the Khap panchayats, sometimes they go also for the penal punishment. Ke wo usko judo ka har pehna, all those kind of jeans nahi pehna, and all those kind of they can issue those kind of fatwas. They go by the religious and all kind of local customs. So again, that is a whole sort of difference between these two kind of systems. And the Panchayati Raj institution, as you say, that those are being created again constitutionally by the constitutional provision in 1992. So again, they are being controlled by their own system. So they have SDO level and different kind of levels. So again, it's a government thing where government is providing kind of training to the panchayat officials where they come together to resolve their differences. So again, that is supported by the constitution and the laws. But these kind of systems, the jati, khap panchayats, and all those kind of things, those are not being, they have nothing to do with the government thing. So that is something, and again, the women's movement has, raised objection on various kind of things they have said. The girls ko mobile nahi use karna hai, and all those kind of things that they have said, which was just something again very unconstitutional and illegal. So those are the differences which I see.
Yeah, but I think because they command tremendous moral authority over the community, should like Lok Adalat and people sitting in the decision-making position should also have a dialogue with this traditional community-based panchayats or organizations or leadership. Because then you can even, if you have a dialogue, you can even neutralize them. Some of the extremely, say, cruel or barbaric forms of punishment which they give to so quote unquote deviant. Can with the dialogue can we change them?
Yeah, surely we should have dialogues, but the thing, yeah, that kind of dialogue is essential, and I think a lot of civil society kind of network should come into picture. Training those people into all these kind of things, because a lot of things are being customs and traditions which have been followed for long, and those may be right or wrong or whatever the way they are followed, which is illegal sometimes, maybe inhuman. So that we have to really have a constant kind of dialogues, with people in village and people at the grassroots. So that's why we talk about legal literacy programs, because I went to one of the training program, and where one person who came and he said that there is a village it's being located, so for being cut off from the mainstream, kind of area. So it's located remotely. Now, if the civil society group, the NGO, or the legal service authority, if they want to go to that area, it's very difficult. So now they started using mobile vans and those kind of things to go to reach out to that area. So these are the kind of some of the new initiatives which is being taken in some places, but it should be taken in various other places also, to reach out. Not only physically but also in terms of having a kind of engagement, a continuous engagement for a long time, because these kind of customs like the witch hunting and the Dayan Pratha and all those systems are being entrenched in some of the villages, and in some places we have heard a lot of such cases even for the honor killing. So what should we have a dialogue on women's rights, on laws, on different kinds of social networks, and so even the sati pratha system, which is being uh, we all know the story what happened in that case,
Including
so,
uniform police, they
yeah.
were the ones.
Yeah. So I think that we have to really ensure how to really reach out.
Thank you.
Participants can now raise their question. They can either type in the chat box or question and answer box or raise their hands.
May I speak? May I ask the question?
Yes, Nikhilji, you can speak.
Thank you so much, Shalu ma'am, for giving us all the insights with respect to the legal dynamic and the entire framework, how the things have been happening. I wanted to know, since one doubt that I had was how the entire policy making system fits into, for example, when you mentioned the Lok Adalat system that has been happening. So, but my concern was, as you also mentioned, that even in Lok Adalat as well, the elite members, the elite sect of the community, they get advantage. Which also happens in a way in panchayat, as you said, that the traditional approach they take up, and the higher castes, if we are talking of the villages, they may get some leverage, and they may get the justice in their favor. So, do those kind of things also happen in Lok Adalat, and how effective they become in the entire justice giving system in India? And another question that I had, that when you mentioned that under trials were released because they had spent a significant amount of time under the prison, so the courts release the inmates, as you mentioned. So is it, did I understand it correctly when you said that? I wanted to understand that because I remember when I was doing an internship, I'm a psychologist, and I did my internship with Tihar jail inmates, in which two of the inmates that I worked with, they said that they have not done anything, yet they are going through the entire trial, and they will be released in a week or so because they have already spent some 7-8 months. But the fine, because they could not pay the fine. So, how policy changes can be implemented in India to overcome these, like how the bridge can be built, how this gap can be built in the entire Indian policy system and lawmaking system?
Yeah, so they're answering to your this question about the jails. Now, in jails, now their prisoners earlier, there were a lot of prisoners who have been languishing for years because they have no, like, there when I went to the prison, I worked in jail number 6, that is women's prison, and I worked with some of the prisoners, and there were some women prisoners. They've been there for so many years, and they have done nothing, and their family, they were not willing to take them back because stigma lag gaya, because she's in jail, so we will not take her back. Uske bacche bahar hain. And sometimes the women, they have murdered the husband because the husband was so violent, and there was something happened, or sometimes murder nahi bhi kiya, but still the woman is being put in jail. And now neither her parental family nor her in-laws family, there is no one outside who can support this woman. And she has small children outside, nobody to look after them. So there was no policy at all that how these, if woman can see her children, or her children could visit her to jail, or if there could be some provision where this children could be taken care of. So slowly we have a lot of work has been done in this area. Now they are talking about keeping children with the women prisoners. Now there are prisoners who don't have anyone to कि वो lawyer को भी लेके आ जाए, to provide them help, or even अगर court का order हो गया, so to arrange for the surety. So there were a lot of problems of these kinds which are happening, which are still happening. उस time तो थी भी, but maybe these kind of things are happening. So how to really deal with this problems? Now the law clearly says that no person should be put behind the bars without any reason. So, but these women are languishing without any reason. There is nobody to help them. So there should be kind of proper policy, proper system, proper mechanism, which should ensure that women could, agar मैंने कुछ crime किया है कि नहीं किया, but at least I should get the trial, and trial होने के बाद, I should be released. Yeah, I can be released on bail, or if I have children, what should be done to them. So these kind of things should be taken care of. So in that kind of situation, the role of policymakers become important. That what kind of policies are you going to introduce for such kind of cases, and more in terms of even the younger women and men who are there, behind the bars. So unke liye aap kya policy banayenge? So these kind of questions are there. Now coming to your next question, that is about the power dynamics which played even in the Lok Adalats. Yes, surely these kind of power dynamics are being played in some cases, which in some cases it's easier for both the parties to come and have a kind of reconciliation or settlement, but not in all cases. For example, if I can give you example from my family court cases, where in many cases compromise is being done, but which cases may compromise is not possible because of the power dynamics which are playing, and if the person is if the husband is beating the woman, and the family court says that no, you go back because there is bachcho ka kya hoga, and to save the family. So those kind of power dynamics are there. So will you now the question of the policy is that can you push this woman to go back to the violent home without any guarantee of safety or security, just because you want to save the family? So these are the kind of questions which are there for you as policymakers to decide what should be done in this kind of situations. Your third question is about what? Sorry.
No, ma'am. Only these two questions were there. Another, when you mentioned the last part that you said, with uske बारे में I wanted to ask कि तो इसमें भी मैम थोड़ा सब्जेक्टिविटी तो होगा. All these people who have, for example, you said the chairman or the lawyers, they are retired practitioner lawyers who have already practiced law. So वो subjectivity will also affect the judgment, right? Like the compromise that, as you are saying. Also, I want to understand what is the difference between the compromise that you are referring to and the verdict, or whatever the legal term is that you say in the law framework, in the justice framework. I wanted to understand that.
The subjectivity होगा, but subjectivity को हटाने के लिए now what is happening right now is that if I'm going to the court saying that my husband is beating me, and they say, you have a kid, you want to save your family, just go back to your husband, even if he's beating you. So जो domestic violence act बना है उसमें भी, if you are doing that, because you don't have shelter homes, so they don't have any option to send me to shelter homes, because jitne bhi shelter homes they are now full. So what will you do as a policy maker in this kind of situation? How will you help me? Just because there are no shelter homes, there is no kind of work available for me, no job placement, so you will send me back क्योंकि मेरा कोई economic arrangement नहीं और हो सकता. So will you push me back to the violent home? So these are the kind of questions which are there, which we need to understand and resolve, in this kind of situation. So this is the kind of compromise I'm talking about, because if
Yeah, I understand.
Sorry.
Yes, very much clear, ma'am, now.
Yeah. Okay.
Thank you so much, ma'am.
More questions from the participants? Anyone?
Hello, ma'am. I have a question.
Yeah.
Yeah. Am I audible?
Yes.
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 You are audible, Ehsan Jamil ji.
Yes.
You may speak.
Yeah. So, ma'am, since I'm working in this area of legal literacy, so I have some lived experiences. So, as you said, you mentioned certain thresholds that our family income should be 3 lakhs or 4 lakhs for different states to avail this scheme. I think women, irrespective of their financial status, and women and other marginalized groups like SC, ST, and other people, they can avail if I'm not wrong, they can avail the benefit under this scheme, irrespective of their financial status. So, firstly, there is a lack of knowledge, lack of awareness. One of the domestic workers I met, she was a victim of alcohol abuse, and she said she was not कि court में तो बहुत पैसा लगेगा, it's very cumbersome, and she didn't knew that. And when I told her about that scheme, she was so reluctant, because so what I need to ask her is, this is also a part of my creative project, because I was planning to write this I was considering to write this for the past 6 months, but I was trying to address this in a research paper for the past 6 months, but I couldn't because of day-to-day activities involvement. So what I was saying, mostly these legal awareness, legal literacy programs are 1 day programs, like 1 day programs and 2 day programs. College students taking up the initiative for they are going to a certain place for this 1 day visiting and disseminating all legal information and coming back. So how do you think that this one of these practices, this structural inequalities, the patriarchal tendencies, and everything, they have been embedded into the society for over centuries. So, don't you think just giving them like 1 day of legal awareness can rather lead to a rather disastrous results? So, don't what's your take on that?
Yeah, so I see two kind of questions. One is relating to legal aid. Now, that person, that domestic worker, she's reluctant. Now, why she's reluctant? Maybe because she may have heard the stories about the kind of legal aid, the way the legal aid lawyers work. Because I have also heard those stories, which says that legal aid lawyers, they don't come to the court. They have a lot of number of cases, so they are not attending to the clients. Clients are being made to sit inside the court and outside the court for hours. Affidavit sign करवाने के लिए पूरा दिन उसका current wage for that day will go. So those kind of issues are there. Why those issues are there? So we have to go into the in-depth kind of evaluation of why legal aid lawyers unke service say they are not satisfied. The clients are not satisfied. So somebody has to do that kind of survey, that legal aid lawyers ke service say people are not satisfied because maybe they may be being paid very less. The lawyers being paid less, so they are not taking interest in the cases of the clients. And the other party could be powerful, and that's why legal aid lawyer nahi aa raha hai, uska case kharab ho gaya. So those kind of issues we have to see that what is happening at that level. Secondly is about your question on legal literacy. Now, legal literacy mein 1 day programs are happening, but kuch, at some places, in some government department, it could be 1 day program, but there, I have worked with NGOs like Indian Social Institute. They have been conducting program for 1 week, for 10 days, for 3 days, for, depending on the kind of groups they are working with. Earlier, that used to happen. But right now, of course, with funding being reduced for NGO sectors, those programs are becoming less and less. So that is the problem. Again, the resource crunch is there. So we can have more number of legal literacy kind of for more number of days. So this is one thing. Another thing is that introducing the law in terms of in schools, in colleges, can we introduce legal courses? The civics ka course mein they talk about constitutional rights, but can we also talk about say women's rights? Okay, if somebody is bad touch, good touch is okay, but if somebody is doing some kind of violence, what should you do? So those kind of questions. Okay, if you're going to the police station and your FIR is not being filed, what can be done? Those kind of questions can be introduced somehow in our schools and colleges and professional courses or whatever courses we are taking up. So these kind of things, I think, may help, because generally now people are getting a lot of information from TV and media, but जो Bollywood movies बनते हैं, what kind of the legal system they are showing, very dramatic, melodramatic. So a lot of clients which are coming to me say कि आप तो ऐसा नहीं बोल रहे हैं, ऐसा नहीं कर रहे, so वो जो एक expectation जो बन गई है अलग से. Now we have to really how will you show them that this is not the way the courts are functioning? This ऐसा dramatic drama जो किसी टीवी सीरियल में या किसी बॉलीवुड मूवी में दिखा दे, that is not happening actually on the ground. So what should you do? So all these questions are there. How will you address these questions? So these are the things which I really want to raise.
Yeah, I just wanted to ask about the fast track court. Where do they? What is the status of fast track court? Do they come under legal aid rubric or separate this?
No, ma'am, they are separate because they are dealing with criminal cases. So they are dealing with, say, POSCO wala
But
case or
who pays? Who pays?
No, that is the criminal, cases which are going over there. So if I'm as a child being raped or sexually harassed or whatever, that the police will do the investigation. The police will file the FIR. I have to be there only as present there as a witness. So I have
But
to
the
give.
whole
Yeah, so-
complete cost will be covered by the state.
Yeah, by the state. So there will be a public prosecutor who will be taking up the case. Now, what kind of services that person is providing, that is again a kind of a debate, kind of a thing which could be there. Uske paas itna case load hai and he or she can't focus on my case. So that is another kind of thing. But here a public prosecutor will take care of
So
the
can public prosecutor and the legal aid lawyer be the same?
Ma'am, legal aid lawyer generally are different. The court can assign a legal aid lawyer specifically if the court says that, okay, the situation is different and a separate lawyer is required. But otherwise, criminal cases may be, basically it's a public prosecutor which is taking up the case. For the civil cases, maybe, if I have to file, say, for maintenance, if I have to file for say, divorce. So then if I have to go to the court and I don't have money to pay to the lawyers, so then I can go to the legal aid, that lawyer.
So there is no overlap between legal
There
aid
is
or
certainly
lawyer
no
and
overlap, but it all depends on again the court system kind of case. So a lot of factors do come in.
Nikhil ji is raising his hand.
Uh,
I have, excuse me, I have like a follow-up question. So the public prosecutor has to be, if I'm not wrong, he represents the state now. If I am a victim of child abuse or sexual abuse, then I can hire my own personal lawyer.
Yeah, if I am so resourceful, I can hire my own lawyer and who can help the public prosecutor.
Okay.
But he or she can't, actually, they can be there in the court and they can intervene. But basically, the entire major role
Okay.
will be played
Okay,
by
the wakalatnama has to be filed by the
Wakalatnama has to be filed.
public prosecutor. That's okay.
No, the wakalat uska to already hai, but if I am hiring my own lawyer, so that lawyer has to file wakalatnama.
Okay.
On behalf of the victim, that okay, I will be presenting this victim and I am her lawyer, so therefore I'm filing my wakalatnama, and then every time you can intervene, but it all depends on the court, because I was representing a POSCO case in Delhi court recently, and there I was representing the victim, and the judge says, and there was a bail, anticipatory bail application proceeding was going on. The accused person has applied for bail, and I just want to say that please don't grant him the bail. And the judge never listened to me. So I requested the public prosecutor that you please say that, and he just refused to talk. So I was feeling, that just because of my thing, I'm just trying my best, but they are releasing him on the bail, but if the person is being released on bail, he may attack the victim again. So for me, this was a dilemma.
Oh. Thank you.
So I had one more question, and if I'm allowed to ask. So, Vibhuti ma'am, I wanted to understand, मैम ने शालू मैम ने एक बात कही of the reintroduction of the terms to demystify the complicated law in the system. For example, disability को differently abled बोल दिया, दिव्यांगजन का term दिया, या फिर एकल महिला. Ma'am, I wanted to understand to what extent does it impact and affect the law making and the policy making system in India in contemporary times?
I think this is like keeping the individual into consideration, the dignity of an individual and how the community wants to be introduced. No, so it is not only the law can't be always vertically imposed or just by the quote unquote experts and elite. It is what is the feeling of the people, no? We call our mother, we don't call her husband, mere baap ki biwi, no? We call her mother, because that is the dignified way of saying this. So if a person who are physically challenged, they say we are not disabled, we are differently able. Each one of us has a various types of disabilities in different phases of life, okay? As a child, you can't go out on your own. As an elderly person, you are more prone to fall. So why just decide, make certain people as a disabled? They said, instead of, why don't we say, we are differently able. I may not be able to walk, but I am very articulate as a speaker. I may not be able to see, but I am an excellent singer. Why give this label of disability to? So that is the argument by those who don't want that term to be used. They said, call us differently abled. All of us are differently abled. You may be extremely good in mathematics, but you may not be knowing that good with languages, no? Or you may be excellent as a poet, but you may not have any mathematical skills. For that, will you call that person disabled? That is the philosophy behind that, is that how they want to be. The slogan of disability movement is nothing about us without us. Please ask us how we want to be introduced. And that is why. Ekal Nari, earlier the term which was used was a Ekal Nari. Instead of that, they would call her Parityakta, or in Maharashtra, they called her Taklidi Baya, or a deserted woman, or a widow. So Ekal Nari, their argument is that why do you link our status and existence with marriage? Marriage is not be all and end all of everything. When it comes to man, you don't signify his status by marriage. Why should it happen with us? Why would you call us either a divorcee or spinster or widow or deserted or abandoned? Why? Who are they to abandon? I am an Ekal Nari. I am fighting for my rights. No? So it is their self-introduction which we need to respect. So this is now they are a constituency. They are vocal. They have their own charter of demand, and they know. And language means a lot for any person's dignity. No, the way like earlier we had so many derogatory names for Shudras and Atishudras. All of them now, if you use them, you will be caught under Anti-Atrocity Act. It's not allowed. They want to be introduced as a Dalit. We have to call them that. No?
Thank you so much, ma'am. This has been a doubt in my mind for very long, since I have my brother-in-law who is also differently abled. But I actually understand it now that it's more philosophical than to actually look it from a perspective of like the concrete stages of law making or policy making. The initial is the philosophy of behind it. Thank you so much.
Yeah, because the moment you call them disabled, you are not interested in them. No. So law and policies, they have to come up with different things for different. The way you have a different laws for children, you have different law for and programs for elderly. You have different laws and programs for women. Same way, they are differently abled. So maybe you are providing them wheelchair, okay, or the people who are visually impaired. The best announcers of local train in Mumbai, they all are visually impaired, but they are so particular. They don't even miss 1 second in the arrival, and in Bombay you have to count every second when about the arrival and departure of local trains, because on one track 220 trains are running up and down, no, and all that is maintained by the visually impaired announcers, no. So how can you call them disabled? They are not disabled. The whole Bombay's the arteries and veins are running because of their correct announcement. They see to it that accident don't take place. They are making perfect this thing coordination with the trains and the passenger commuters.
It's been similarly about the LGBT movement. The entire movement emerged, because of the way the people are being stigmatized. वो जो language यहाँ पे जैसे उसको term hijra या kinnar या whatever terms you're using, those were very derogatory terms. And now we are talking about transgender act and transgender laws, and so the entire if you see the journey from that to here, we're talking about the policy for LGBTI. So, these kind of things you have to really take into consideration, that how the movements have played a very strong role for continuously for so many decades, that now the rights of people are being recognized.
And all of them, they, in the very beginning, they tell their pronoun, how we have to address them. No? So that also they make it very clear. So that that's and they see it as a very important fundamental right for the people, and lot of identification of LGBTQIA community with the disability movement. In fact, they drew inspiration from the UN Covenant on Disabled People's Rights. They are persons with differently able. Yeah.
Thank you so much, ma'am.
Khushbuji is raising her hand. You may speak, Khushbuji.
Good evening, everyone. I have two questions. One is on how to reduce the burden on the legal systems, and the second one is about the legal literacy. First one, I have to ask you that there are many ways of reducing the burden on the legal systems. Specifically, if we see the rural area where the legal literacy is also less, what are the alternatives or effective alternatives according to you that we can offer them legal assistance? And second thing is the legal literacy as far as the viral reels on the social media is concerned. Even there are lawyers who are making reels and they are sensitizing people, the masses, about the legal things, about divorce or anything which immediately connects. So how effective is that, and how can that be in an effective way to communicate to the people about the legal rights? Your take on it.
Yeah, so one thing is about the legal literacy, and specifically in the rural areas. Now, if you go to rural areas, there is a whole study by National Family Health Survey, and it says that wife beating is being recognized, is not being even recognized by women. That they say, like, it's okay for husband to beat me if I have, मैंने खाना जला दिया या बच्चा रो रहा है, or if I've just obeyed my mother-in-law, so that gives my husband my right to beat me. So those kind of stereotypical whatever you say, it's kind of conditioning, which has not been gone as yet. So first we have to address that kind of the kind of things, the stereotypes which are there, the kind of the way the patriarchy still exist. Even the women think that way. So we have to really see that how should we go about that. So before talking about say legal rights of a woman, domestic violence ka criminal case file kar do, ya domestic violence act mein case file kar do. So we have to first really see ki okay, uska husband usko maar raha hai, but can we really do something in this kind of situation? So first thing is this. And so these kind of things we have to really see ki kaise kaam karega, because just telling them ki because I went to a lot of legal literacy programs, and when I start talking about directly कि ये domestic violence का law है, 498A है, and you can send your husband to jail if he's beating you, and those women, they may feel surprised कि मतलब what she's saying, कि कहाँ से आ गई, मेरे husband को jail भेज देगी तो मुझे खाना कौन खिलाएगा. So those kind of things are there. So to really see कि what kind of legal literacy program is required for whichever group you're talking to. So those kind of dynamics we have to really ensure कि something should be there. And your second question was about sorry, I forgot.
The second was
assistance.
legal assistance in the rural areas.
Yeah, legal assistance in rural areas. Again, we have to talk about, say, lok adalats ka jaise hai, like, I was talking about this remote area mein, like, taking the mobile vans where the lawyers are going, where the judges are going, and they are talking to people, so they're addressing the local issues which could be resolved amicably. So those kind of things. So in that case, we have to really go and, talk to the community. Because some of the villages they are so remote, and people may not be educated or literate. So what kind of policies you can think of, or training programs you can think of in that kind of situation? So legal aid to provide karna hai, the lawyer can really go and talk to that person, but also talking about different kinds of innovative ways to resolve disputes. So lok adalat is one thing where uh, where people, the parties can be brought together. So these are the things, I could remember legal literacy program. I was taking this session at the Indian Social Institute with a group of, NGO workers. And there was a person who came to this program for the third time, and this program was for 10 days. And every year, Indian Social Institute was conducting this program. And for third time, he came, and I asked him that why you are coming again and again, because you already now know this program. And he said कि नहीं, whatever मैं यहाँ से सीख के जाता हूँ, मैं यहाँ से दो चार sections के बारे में मैंने सीख लिया. So I went to my village and I talked to them कि ये section आप पुलिस वाले हैं, आप केस नहीं फाइल कर रहे हैं, I will file ये section लगता है, ये section लगता है. So I just pretend to be a lawyer, and that really gave me a confidence. So, these kind of things are also happening at the ground level. So it all depends, how people are using the law creatively. So that's why we are talking about social movements and civil societies and NGOs, because sometimes they bring in a lot of, grassroots level experience, and that could really, so there should be a kind of dialogue between grassroots level workers and the judges, because most of the time I have seen a lot of lawyers in Supreme Court and the High Court sitting in ivory towers and talking about the law, but you need to know the ground realities. So even if you're making the law, even if you're implementing the law, you need to understand what is happening at the ground level. So that kind of connection has to be drawn, and for that we need to do a lot of research. We have to talk about policy making. We have to talk about a lot of other things, because law सिर्फ courtrooms में operate नहीं करता. Law is also operating outside. Because even if you are, when I went to this village, and then they say कि आप सबसे पहले तो आप मेरा राशन कार्ड बनवा दो, मेरा राशन कार्ड नहीं बन रहा, so that is also a kind of law. So you have to engage with the state. You have to know that ration card banane ke liye what are the procedures, so those kind of things you have to really think about from where to start, how to start, and what are the creative ways you can use. So what I have to do, I have to get her ration card made, and then come to her problem of her alcoholic husband beating her. So it's not the direct intervention. I can't say कि नहीं मैं सिर्फ वकील हूँ तो I'll make court में case करूँगी. I have to talk about different other ways.
So,
And I
ma'am,
think
is it
that is,
feasible? Yeah.
Yeah,
may
go ahead.
Yeah. Is it feasible to appoint some representative from the village itself and equip him with the legal aid and legal literacy, that he can also sensitize people in his area? Like there was a time when RMP were there. There were no MBBS doctors or somewhere. So in village, in remote areas, it is very difficult to reach out to medical services and also legal services. Like you said, the lok adalats and all. The villages cannot be reached many a times. So the legal assistance can it be provided by the representatives, and they can be trained? Is it feasible?
Yes, sure. Paralegal training programs were conducted, by a lot of NGOs. अगर 80s 90s में आप देखें, lot of NGOs were conducting paralegal training programs. So paralegals are what? They are not lawyers. They are NGO workers. They are based there in the village, and they have been provided training by the NGOs, and then they come for this legal aid training. So the story I was telling you about this guy who came for thrice for this legal training program. Now, this guy was a NGO worker who was based in that village, and he just want to learn the law, ताकि वो he can go back and he can use that law to help people. So these kind of things really help, where NGOs, people from NGOs are working, or you can connect the universities, the law universities, or the women's studies department, or the, various other departments, and they connect, adopt a community. Because when I did my MSW, MA in social work, we used to go to the community every twice, like as a student, of MSW. We are supposed to go to the field, to the village, to the local village or slum twice a week. So there we used to go, and that inspired me to really learn the law, because when I used to, जब उनसे बात किया, I understood that they have some legal issues which I really can't help, because without any legal knowledge. So I took up the that legal Kapoor education. So this is the way that universities can take up such kind of courses, where students can visit the fields and talk to people and talk about social development. So instead of having the class of social policy and social work, or whatever sociology in the classroom, you can also go out in the field and can talk to people. So these are different ways where how the law could be connected to the sociology, to the policy making, and also students can learn a lot when you're going into the field.
Absolutely. Thank you.
Shalvi Shah ji is raising her hand. You may speak, Shalvi Shah ji.
Thank you so much. Hello, Dr. Shalu, and hello, Dr. Vibhuti, ma'am. I just had a quick question. So while I was doing a research, and when we are conducting different drives and campaigns for women who are affected by the idea of a lack of menstrual hygiene, and while we were conducting that research in the Gujarat prisoner cell, specifically in Ahmedabad, we were able to find out that there are certain psychological factors which also comes into the picture when we talked about menstruation. So I just wanted to understand that what are the policies that the law has when it comes to women in menstruation who are in jails, because they're already in a in a confined area where that gets much affected psychologically and physically as compared to us, where we get comfort during that specific month or during that specific period of the month. Yeah.
Yeah, so in terms of periods in jail, that is again a very kind of whatever you say, it's a very difficult issue, because when I was visiting prison, and I find out that they have a ration system.
Correct.
Very few sanitary pads are being given. If a person is going through her period, so then she has to ask to the that prison guy in charge that I need sanitary pads, and then they will just give whatever number 3 or 4, whatever those numbers. So these kind of things were happening, and slowly we are just trying to ensure that sanitary pads must be available for free to everyone. Like Supreme Court, there was a petition which is being filed that Supreme Court, there should be a kind of machine. Sanitary pads must be easily available. So we have to we filed a case in 2021, and then Supreme Court has asked the state government to allocate funds for that. So these kind of things. It's going on. It's a continuous process. It's a long struggle which is going on. So for prisoners, we need to have a kind of vending, the kind of sanitary pad
Period bank.
machines there should be there within each premises, but that is not there.
And also the period pain, acknowledgement of period pain in the kind of work, if they are in a, say, kitchen department, or if they are doing manual work, or if they are in the cleaning department, the workload which they have during the period, I think they should listen to. So that kind of a counseling of the doctors. So in gender in medical education also we have to bring it, because prisons also have doctors, and there are jail superintendent also has to be sensitive about the period pain, discomfort, contraction, because it varies from person to person. So even that should be included in the prison manual as well as the sensitization program, because all the jail authorities and prison authorities also have to periodically undergo refresher courses about prison reform. So in that, I think we should include that it is a very important reproductive right.
That leads me to a second question, a follow-up question on that. So at a ground level, what can we, how can we be the catalyst of change? So that we can speed up the process. I mean, when we talk about Gujarat, when we talk about the women's cell in Ahmedabad, how can we actually create a change so that the prisoners right now, or the coming whatever the prisoners would be posted in, they would be kept in this particular cell. How can we change that process, and how can we fasten up that same?
4-5 things that we can do in the very first lecture. I think that in the other course, Mr. Vijay Raghwani said that participatory action research on the subject, collection of data, evidences, submitting a report, then preparing a charter of demand, or doing advocacy whenever we are invited for gender sensitization program of government, of state government or central government, bringing up these issues which are generally never discussed. No? So, and also writing about it in the newspapers, media, talking in the FM channels, and wherever, like if you are working on menstrual hygiene, you are not only talking about the rural women and urban women and young girls and school girls and working women and housewives, but also women prisoners. So never not to leave them, because whatever is not mentioned, it always remains invisible. Nobody takes any action about it. So it is very important to visualize and vocalize and amplify their voices.
Right. Thank you so much.
There is another additional thing you can do is you can talk to the prisoners, the DG prisoners, the staff of prisoners, they have meetings. So if we get this opportunity to raise it there, or also about filing a public interest litigation before the high courts or the Supreme Courts to ensure that they have this kind of policy, or even at the policy level, what the Ministry of Women and Child Development is doing for women prisoners. So those kind of interventions we can also think of.
Even there is a portal of National Commission for Women, State Commission for Women, and the Ministry of Women and Child Development. In that also they have a window to civil society. So as a citizen also, they can write to them on that portal.
Understood. Thank you so much. Thank you.
Any more questions from the attendees?
You all have decided your topics, no, for project? Creative expression.
I think no more questions. So thank you, ma'am. It's always a pleasure to be learning from you. As we come to the end of day 3 of LPPYF, Law and Public Policy Youth Fellowship Cohort 3.0 Summer 2024, Advancing Justice, Bridging Gaps in Public Policy Enforcement, an online national summer school program, a 1-month immersive online law and public policy awareness certificate training course and internship program. I, Ritika Pandey, researcher at IMPRI, Impact and Policy Research Institute, would like to propose the formal vote of thanks on behalf of IMPRI, New Delhi. We are grateful to our experts for the day 3 session. Advocate Dr. Shalu Nigam ji and Dr. and Professor Abdul Hafiz Gandhi ji, who is not available today, for taking out their valuable time and allowing us to learn from this online certificate program. We thank our chair, Professor Vibhuti Patel ji, for convening all the sessions. We thank all of our participants who have raised pertinent questions and actively participated in today's deliberation. We look forward to welcoming you on the next Tuesday, that is July 4th, for our day 4 of this certification course. We are grateful if you are watching us later on YouTube or listening to us on various podcasts or reading our publication. We hope you continue to join in future to our IMPRI Web Policy Talk and Web Policy Learning. Wishing you a good day. Thank you.
Before we leave, I request all of the participants that if anybody has, we have a hand raised by Shalvi ji, and if anybody else also wants to discuss their topics, please do so now. And we will also be having the closing remarks from both of our chairs.
Yeah.
Can I go ahead with my question?
Yeah.
Yes,
Uh,
Shalu.
Yes.
I just had a question regarding my research. So the guidelines do suggest that we have to have a 3,000 to 4,000 word research paper. But since I've taken a live case study, I'm taking that approach for my research. It is exceeding the word limit because it includes
How much?
it has already till the part that I've reached to the literature review, I've been able to come up with 4,000 words till then.
You compress literature review, make it precise, just make the subheadings and summarize whatever you have read. Don't go by each and every book and report. Extract the thematic areas and this, because your own finding primary data which you are bringing up, that is far more important. So research,
Correct.
your review of literature can be of maybe 500 to 700 words.
Okay, understood.
Shalvi ji, you can make a bigger report,
Okay.
but
That
the
can go
book
in that.
stick to 4,000. Matlab, in the guidelines document, we have mentioned that various sizes of article, how you can give. If you have a bigger paper, you can submit it at other place also, no?
Yes,
Make some other topic, make it a book chapter, 10,000, 12,000 word, make
correct.
it, present it at a conference. You can also, if it is, let us say, going 15,000, 20,000 word, आप उसका एक document भी बना के ना academy या research gate वहाँ भी put कर सकते हैं. जैसे masters का dissertation होता है ना.
Right, right.
But for publishing, try to stick to 4,000. अगर थोड़ा ऊपर नीचे भी जाएगा तो कोई बात नहीं.
Understood.
But try to stick to that so that it's coming in the edited volume. So the word limit is for the edited volume. Other than that, if the project is going further big, you can make it as your own submission, that project kind of document that you can show further in your career anywhere where you are going.
Yeah.
So just
And
to
for
take
peer-reviewed journal, it is 8,000 words. For peer-reviewed journals, they
Yes.
have academic journals, 8,000 words. For newspaper articles, 800 to 1,000 words.
800
Yeah,
to 1,000, 1,200 words.
So just to get a clarity, I can work on the research for now. For the publishing part, I will keep it concise to 4,000. But
Yes.
I can submit a different whole report, which is more in the number of the words because it is more detailed. So I can make
Yes.
two submissions if per se.
Yes. Yes.
Yeah.
That will
Okay.
that will be
Right.
that
Got
will
it.
be.
Thank you so much. Thank you.
Yeah.
Amongst the participants, do we have anybody else who wants to discuss their abstract?
Have you started your field work? Have you started your review of literature? That also you can share whatever problems or challenges you face conducting interviews, identifying the respondents.
Ma'am, the topic that I have selected for in the SDG goals and the disability rights. So it was very difficult for me to like currently right now difficult for me to get the primary data. I was trying to interview people. I have taken 3 case studies of 3 different states, but I will as in it will take much more time to gather the subjects, the participants for the research study. So in case if that doesn't happen within the given time, the stipulated time, can I go ahead with the secondary research, that is the material available online, and can I reduce the sample size?
Yeah. Sample size means you can take the metadata on disability from National Family Health Survey also, so that you will get it. There is another is SRS data. You can get census data. Census also gives data on it. So quantitative part can be taken care of. But there are many studies done by, if you see, there is a special number edited by Renu Adlakha, or there are articles by the disability movement has come up with many country reports, because they also have a status in the UN, UNHRC and all that. So even all those reports written by various researchers, if you go through Shodha Ganga or in FlipNet, You would get also many PhD theses written by the social workers or psychology department students. So that would be rigorous research on disability movement of over last 3 decades you can take up, because that's why it got momentum, no? So a critical reflection of the existing literature you can do, and you will get both quantitative as well as qualitative data from the secondary sources. And also you can reflect on the various GRs and the subnational, different states have a different policies also. The budgetary allocation you can examine, because now we have a separate budget for the persons with disability. The policies of a quota or the reservation policy that we have, you can reflect on the legal laws, policies, actual situational analysis of disability, persons with disability, types of disability, and the infrastructure. So 5 sections you can have. It will become a 4,000 words article.
Okay. Thank you.
Nikhil ji, if you will look at also the ministry's annual report, वहाँ भी the state of disability ऐसा का पूरा आपको data मिल जाएगा वहाँ.
जी.
Ma'am is saying no, NFHS वहाँ से तो मिल जाएगा, पर आपको combined और updated report मिलेगा. Refer to them. Focus more on, if you are trying to focus on case studies पे focus कर लीजिए. Sample size में time चला जाएगा, so be very careful.
जी. Yes.
Yeah.
Secondary, हमने भी पहले वैसे कुछ रिसर्च किए हैं डेटा, बट एवरीथिंग इज अवेलेबल. तो आप मिनिस्ट्री का वो देख लीजिए, जस्ट डू सम गूगल लिटरेचर रिव्यू भी. हमने गाइडलाइंस डॉक्यूमेंट में कुछ एआई टूल्स भी बताया है लिटरेचर रिव्यू के लिए. इफ यू जस्ट गूगल इट, आपको मिल जाएगा काफी कुछ.
जी, श्योर, थैंक यू.
Anyone else would like to discuss their work? Chahak ji, Zarna ji.
Presentation time. Okay.
3 to 5 minutes, 4-5 minutes.
So you can have around 7 slides. Then fine, no? 7 slides. So one on the situational analysis, research, your methodology, research methodology. Then the problem discussion. Then recommendation, bibliography, and areas of further studies. Okay. I think 7 slides should be.
Okay. Anyone else? Don't be afraid.
All of you have started your work, review of literature and field work.
Our team will also be in touch with you. हमने WhatsApp group भी बनाया है. Try to be active towards weekend. हमने guideline document बहुत कुछ दिया. अगर आप smartly करेंगे ना, तो complete कर लेंगे. हाँ.
और 1-to-1 भी करते हैं. We are answering your emails.
Yes.
Immediately. We are not taking long.
Yeah.
Immediately we are answering.
Give a draft flow भी आप दिखाएंगे ना, विभूति मैम गाइड करेंगे. हाँ, quickly. ठीक है.
आज भी आए थे क्वेश्चन, सब 5 क्वेश्चन आंसर.
If we don't have any other participant, then shall we go for closing remarks?
Closing remarks.
Vibhuti ma'am, ma'am, I would like to invite you.
The most important learning that we had from Advocate Shalu Nigam's presentation on legal aid is one thing that realizes that knowing law is one thing, but also creating a support system and institutional support to those who are fighting. That is also very important. And that's why in the women's movement, we always say that along with the legal movement, legal awareness, we also need to do the hand holding of the person who are at the receiving end. Whether you a person from the weaker side, because legal aid is meant for people who are facing multiple marginalities. So they can be tribal person, or a farmer, or activist, or an unemployed youth, or a homeless person, or person with disability, or women. All of them need institutional support. So that is very important. Otherwise, those tragedies and the case studies which Shaluji discussed, that a woman is battered, but she doesn't have an alternative to alternative support system, or she doesn't have any alternative livelihood needs. then she has to be in that violent situation. So if we want them to fight for the justice, along with that fighting legal case, out of court support is also very important. And that is why NGOs, community-based organization, social movements, senior citizens organization, child rights organization, human rights organization become very important, because they do the hand-holding at the time of it. Because legal battle, as right from Mr. Shailesh Gandhi to Shaluji's testimonies, they are showing that it's a long drawn process. And that's why standing by the people and providing institutional support, individual support, support of the community, ensuring that it becomes very important. Then only the formal democracy or formal justice becomes substantive justice.
Thank you so much, ma'am. Shalu, ma'am, would you like to say something?
Ma'am has already she's go in a very simple language she has explained. Yeah, but surely when we talk about the legal system, we have to talk also about the social system. So the both are interconnected. So that's why we have to ensure that kind of a bridge is being there between the law, because to quote me over there, that is not the only law. There is law which is also happening outside, and we have to see that what kind of things are happening outside, the how people they are facing problem, and how can we provide justice. So can we really provide justice, or so those kind of engagement, those kind of conversations, those kind of dialogues are important, and they need to be continuous, and they need to be both sided. So it can't be just the courts giving judgments, but, because we have seen that in terms of people's houses were bulldozed. So and earlier we have this Olga Tellis judgment, which says that the poor people, their houses shouldn't be raised like that. And now, we are seeing a different kind of judgments which are coming from the courts. So that's why we talk more about, the law outside the court. That that kind of democracy should be strengthened. That the courts, with the courts should play important role, and also people should be able to raise their voice. So this is the only thing which I really want to say today.
Thank you so much, ma'am. Since we've already had the formal vote of thanks, I would now like to just thank everybody for being here today. I'd like to thank the experts, and I'd like to thank all of the participants for being so active throughout the session. So thank you, everybody, and have a very good evening.
Yeah, we had a very fruitful session. Yeah, very